And now, from Time Served Records, the label that brought you the timeless classics, like Judge Simpson and his jazz flute and the geniuses behind Judge Webster sings the Sallyport Blues, for the first time on ever compact disc, DJ John Michael and his hits I Never Gotta Notice. And who can forget I Didn't Lie or Nothing I Promise? You will be soothed by his raspy vocals as he serenades you with the smooth melodies of I Am Not Asking My Pregnant Wife to Pay. And finally, I am new to all of this, so take a minute to listen to a sample. Enjoy.
1-5. And appearance, counsel?
Yes, good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. This time, extended to the matter being heard via Zoom.
All right, thank you. And Mr. Bartolotta, your name, please.
Joseph Michael Bartolotta.
All right, and counsel, as to the arraignment.
What's up, people? How we doing? Oh, we have to get into these two. Oh, these were great. I have so many good. Judge Frashauer loses her patience today, starts yelling at somebody. Ooh, we got a goodie tonight. How we doing, everybody? Welcome, new viewers trickling in. We are savagely approaching 10,000. It's going to be here before we know it. The 10K celebration. I don't know what I'm going to do yet. It is coming. So, without further ado, let's get to my girlfriend, Judge DeSanto.
As the arraignment will waive formal reading, my client stands mute.
Waive the formal reading, enter plea of not guilty for purposes of the arraignment. And as to, the court will indicate that the pretrial will be scheduled for May 30th. At 9:30 a.m. And counsel as to bond.
Your Honor, my client's 43 years old. Right now, he lives alone, but he is expecting a baby in 3.5 weeks with his fiance. They're only living separate because they're saving up money, and she's residing, I believe, with family. He works 6 days a week. He's a very hard worker. He works for Billy's Roofing. He indicates he's not on probation or parole, and that he will appear at any and all future court dates. He maintains that this sort of behavior is quite out of character, and he will comply with any and all terms and conditions. I would be asking consideration for the court to entertain a personal bond. Thank you, Judge.
Okay, and so Mr. Bartolotta.
Yes, ma'am.
10K
You
live
work full time?
Yes, ma'am. 6 days a week, almost 7 sometimes, because we're gonna need the money for the baby. And the weather's finally getting right too, so we're more busy now.
Okay, so then how do you still receive food stamps, sir? If you're working full time?
Oh, because usually most of the time roofing is 1099 or under the tables technically, so. And I actually don't even receive that card no more. This month will be the first time that I didn't hear you, sorry.
Sir, you just filled out this financial affidavit form, correct?
Yes, ma'am. The paperwork, yes, ma'am.
Okay,
About the
and on that document, it indicates it's a felony for you to provide false information. Does it not?
Oh, I didn't lie on nothing, ma'am. I promise.
He promised.
Well, you just said you're not even really receiving those food stamps anymore, but yet you indicated that you received those food stamps on your form. So which is it? I thought it meant like a history if I ever had any type of assistance. That's the only type of assistance I've ever had outside of me working at, my regular job. I apologize. I definitely wouldn't. It's no felony for, a bridge card or nothing like that. At all. What's not a felony for a bridge card, sir? You said something about a felony, and I said bridge card, and I circled bridge card. That's the only type of assistance I've ever had. That's how I was answering the question. I'm sorry. I apologize. Sir, do you receive food stamps or no?
No, ma'am.
You
I don't
don't?
receive nothing but a paycheck. No, ma'am.
No.
Sorry, I'm sorry, my mind's somewhere else. I apologize.
Sir, the question on your
Oh, it's
monthly
raining
income
gifts.
says, do you receive any public assistance?
Wexler.
Not
Oh, man.
did
My
you,
man.
it says, do you?
Sorry, no, I do not, besides a paycheck. I work for my money. That's all I pay for groceries with money. I'm sorry, I'm not used to this.
And
I
then it
apologize.
says,
He's not used to this. What? I don't know. Used to what? I can't. Absolutely. Poor DeSanto. She is definitely taking over as the nuttiest courtroom on Zoom.
that you receive $200 a month in public assistance is what it says.
That's because that's where if you want to say I do, okay. I'm not used to this, man. I'm sorry. I don't even act like this. I got space out my bed that night. I'm frustrated. I got a baby on the way, my first child. So I apologize. My mind's other places. I just need to be out working as much as I can for this baby.
I'm just trying to figure out your credibility so I know whether or not I can believe you.
I mean, you can have the officer check my hands if you want my hands all busted. All I do is roof almost every chance I get. And it's usually dark to dark, so I'm usually into that at night like I was the other night. I thought I having a seizure, and then that's when kind of me and the ambulance people got into our verbal disagreement.
Hold on,
And then
hold on. What's happening with the Flat Rock matter from 2021? It shows that there is a warrant requested for felony robbery.
Oh no, that was dropped not guilty. That was a mistaken identity. I was released and everything.
Okay, what about October? What about October of 21 in Southgate? Felony sexual assault and felony burglary. There was a warrant requested. Whatever happened with that matter?
Oh, hold on. You said what? I'm sorry, man. You said sexual assault. That wasn't me. I don't even have no warrants, ma'am.
Sir, I didn't see any warrants. I just asked if you knew there was a warrant requested. It doesn't show if it was approved or not. That's why I was just asking what happened with that matter.
I would never hurt no woman.
Sir, that wasn't my question.
No, ma'am, I was never notified of it. I can say everything. I've been pulled over numerous times. So.
Okay. What about February? What about February of this year in Allen Park? Dangerous drugs.
Oh no, we were pulled over. Me and my fiance were pulled over at Dixon Southfield, and for
Christopher Lloyd's cracked out son has a answer for everything, and she is extremely patient with him. Dangerous drugs, sexual assault, but he swears he would never hurt a woman. He doesn't do drugs. He roofs. He works from night to night, dark to dark. Okay? There's no way this dude is doing anything wrong. Not at all.
no insurance.
Nothing.
And they said that there was a paraphernalia, and I didn't want to let her go down for it.
He's
Okay.
such
I
a
don't know
good
if it had
guy.
something to do with weed, and because she didn't have a weed card or something like that.
Sir,
But
sir, did you take care of that matter, or is that matter pending? Is there a warrant?
Yeah, he
there is
swears.
no warrant, ma'am.
Did you take care of that matter?
They didn't even arrest us.
What's up, Kitch?
They didn't even go in
I
here.
didn't ask if you, sir. I understand that.
I feel like you're not.
You were sent. Please stop interrupting me. You were sent a notice to appear. So
What
did
up,
you take
Brad?
care of that matter?
I never got no notice to appear, ma'am. I would never avoid something as
I don't like the double negatives either. He uses a lot of double negatives.
frivolous as that. To lose my job and be in jail and everything else. Not with a baby on the way. I would
Okay,
not.
tell me about the matter from April 9th in Taylor. It
Seven
shows
Eleven?
misdemeanor public peace. What happened there?
It's 7-Eleven, correct?
Yes, possible.
Got into a verbal altercation with somebody at a store, police showed up. Further, the altercation further, I went to jail for like 2.5 days, they let me out. That was it, because they say the same kind of scenario, but I got frustrated because I got snatched out of my bed. I was laying at home minding my own business, and
You know, I really don't appreciate the Wyandotte Police Department is all up in this guy's business, ripping him out of bed. He can't have arguments at 7-Eleven. I mean, the guy can't even go for cigarettes because we know he smokes. And like, really? Come on. Come on. Leave this poor guy alone. I feel so bad for him. He does nothing.
they thought I was gonna have a seizure, and I didn't want to be seen by.
Uploading several files of
What
child
happened?
pornography.
What the hell was that?
And appearance, counsel?
Yes, good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. This time extended to the matter being heard via Zoom.
All right, thank you. And Mr. Bartolotta, your name, please.
Joseph Michael Bartolotta.
All right, and counsel, as to the arraignment,
As the arraignment will waive formal reading, my client stands mute.
waive the formal reading, enter plea of not guilty for purposes of the arraignment.
Sometimes my mistakes are great. They suck most of the time, but that one was good.
And as to, the court will indicate that the pretrial will be scheduled for May 30th.
Kitch, I have no worries for him trying to seduce my lady. No worries.
At 9:30 a.m.
She's all
And counsel as to bond.
Your Honor, my client's 43 years old. Right now, he lives alone, but he is expecting a baby in 3.5 weeks with his fiance. They're only living separate because they're saving up money, and she's residing, I believe, with family. He works 6 days a week. He's a very hard worker. He works for Billy's Roofing. He indicates he's not on probation or parole, and that he will appear at any and all future court dates. He maintains that this sort of behavior is quite out of character, and he will comply with any and all terms and conditions. I would be asking consideration for the court to entertain a personal bond.
Is that a fake fireplace? Consensus on that is it's a fake fireplace.
Thank you, Judge.
Okay, and so Mr. Bartolotta.
Yes, ma'am.
You poor thing.
You work full-time?
Yes, ma'am. 6 days a week, almost 7 sometimes, because we need the money for the
Stop
baby.
it, Wexler. Enough.
And the weather's finally getting right too, so we're more busy now.
Okay, so then how do you still receive food stamps, sir,
What?
if you're working full-time?
Oh, because usually most of the time roofing is 1099 or under the table technically, so. And I actually don't even receive that card no more. This month will be the first time that I didn't hear you, sorry.
Sir, you just filled out this financial affidavit form, correct?
Yes, ma'am. The paperwork, yes, ma'am. About
Okay,
this-
and on the back, excuse me, on that
Sorry.
document, it indicates it's a felony for you to provide false information. Does it not?
Oh, I didn't lie on nothing, ma'am, I promise.
Well, you just said you're not even really receiving those food stamps anymore, but yet you indicated that you received those food stamps on your form. So which is it?
I thought it meant like a history if I ever had any type of assistance. That's the only type of assistance I've ever had outside of me working at, my regular job. I apologize. I definitely wouldn't, it's no felony for, a bridge card or nothing like that. At all.
What's not a felony for a bridge card, sir?
You said something about a felony and I said bridge card and I circled bridge card. That's the only type of assistance I've ever had. That's how I was answering the question. I'm sorry, I apologize.
This guy sucks.
Sir, do you receive food stamps or no?
No, ma'am.
Lie.
I don't receive nothing but a paycheck.
Lie.
No, man.
No.
Sorry, I'm sorry, my mind's somewhere else. I apologize.
Sir, the question under monthly income says,
I can't with him anymore. I can't.
yes,
You
the
absolutely
court's going
can't.
to indicate a $5,000 10% bond. In the event you post bond, you're not to be released without an alcohol tether in the Wayne County Jail. You're not to possess or consume any alcohol or drugs unless prescribed.
I'm not gonna be able to post bond, so what happens?
Anything else, counsel?
I'm not gonna be able to post bond, so what happens now? I don't have no family.
Well, I thought you just said you had a fiance that is pregnant with your child.
I'm not taking money from my pregnant fiance.
Oh, okay. So I thought you would consider her family. All right, counsel, anything else?
No, Your Honor.
Okay. All right, thank you. We'll see you back on May 30th.
Oh.
Thank
Bye-bye.
you. We'll be off the record. And I
Act
think
now, and we will throw in straight from Amarillo, Texas. The Condiment sings an absolute chart topper. I start a job tomorrow. These can all be yours for the low price of a low. Price of a like and subscribe to this channel. Operators are standing by. The first 50 callers will receive this commemorative Mike McNally umbrella. Time served is waiting to hear from you.
Okay, so this one, literally, the judge addresses that everybody gets a job tomorrow. It's fantastic.
Okay, so you also have Tapius and then you have some others. So let's start with this real quickly. See what we have. How old are you?
22.
22, okay. That's right. So, okay, I'm gonna start with the ones where you haven't entered any pleas on these, and I'm gonna tell you what they are, and you need to let me know how you plead on them, okay?
Okay.
So, and then we'll talk about the capious, the ones you already pled on and didn't finish paying or do any of that. So, okay, first, let's start with August 12th, 2020. You stopped for and issued citation for failing to maintain financial responsibility. Second fine range on that is $350 to $1,000. You want to enter a plea of not guilty in order to have time to hire an attorney or have a trial on that.
I'll do guilty.
Okay. I have down here that you've been in jail 2 days. Yeah, 2 days, right? Or
Yeah.
what, yesterday and today. Okay. So I'll give you $300 jail credit, release you to report on the remaining balance, release you to report, come see me by 2 p.m. the first business day following your release, okay?
Okay.
So then on, okay, then on July 11th, 2020, you were stopped in a Honda Civic, issued citations for failing to maintain financial responsibility. Second, did I just say this? No, you had another one. Another one of the financial responsibility seconds and no driver's license. How do you wish to plead on those?
Yes, Heineken. Carmella.
Where was that one at?
It says okay, so it was you were in a 2003 Honda Civic and it was on Southeast 10th and South Grand Street.
Okay, good.
Okay, does that ring a bell?
Yes.
Okay, how do you plead on those?
I'm guilty for good.
Okay, on your guilty plea, I will find you guilty, please, I'll find you guilty, and I will be time serving you on the no driver's license, and then you will owe $398 on your insurance. Second, I'll release you to report, come see me by 2 p.m. to talk about how to pay it.
Monica throwing out
And
gifts.
then-
Thank you, Monica.
Chrysler 200 series. This is 3400 block at Southwest 6. About noon, and you were issued citation. Received a citation for failing to maintain financial responsibility, second offense, and no driver's license. How do you wish to plead on those?
Guilty, also.
On your guilty plea, please, I'll find you guilty. So assess the finding court costs, and you will get $300 jail credit. You'll be time served on the no driver's license, but you'll owe $433 on the no insurance second. So I'll release you to report. Come see me, and we'll talk about how to pay that balance. First business day, following your release by 2 p.m. Okay, and then let's talk about your capias. You have, let me see. So looks like you had pled in 8/6 of 2019. You pled guilty to speeding and no driver's license. Let's see, and then also 6/11/2020, you pled to a no insurance ticket. You pled guilty on that. So it looks like you pled for a payment plan on those. You were told you could pay, and we never heard back from you. So here's your total. Your total due with your jail credit. Your total on the capias due right now is $762. So can you pay that today?
No, I can have, my boyfriend can make, like maybe half of that, but that's about it.
Well, it's been 2 years, so, do you have any reason why you haven't contacted us or you didn't pay?
So whenever, it first happened, and I think, whenever I, first made the arrangements and stuff, I had got accepted into a job course, so I went to Kansas for their school. And whenever I came back, I forgot about them for a little while up until I think maybe about a month ago when I got pulled over. The officer had told me I had the warrants and stuff and the KPS fines, and I just haven't got a job yet. So but I haven't called or anything like that.
He told you about him, but he didn't arrest you for him?
Yes, because yeah.
Yeah, okay. All right, well, did you call or try to make any effort once you knew about him?
I called last week, and I was just kind of asking, if I come up there to try to make arrangements, but I don't have any money, am I going to go to jail? And they basically said, no. So this week, I wanted to go sometime this week because I start work tomorrow at JBS, or I'm supposed to anyway.
Okay.
Oh, there it is.
But no, I haven't been calling for the last few years.
So let me look at these comments real quick. Just give me a second.
See a lot of new people in the chat. Welcome, everybody.
Oh, okay. You were set for a show cause hearing. That's what it was, I think. Hold on.
What is that?
Well, let me see. Just no, I had it wrong. Okay, just a second.
If you need anything, our mods will help you. They are the best.
Are you working now? You're going to start working at JBS, is that what you said?
Yes, I'm supposed to start tomorrow morning.
Oh.
Okay. How much are you making?
I'll be making $22 an hour.
Wow. 40 hours a week?
Yes, 48 hours. Guaranteed 48.
Where, you're starting tomorrow?
Yes, I'm supposed to start tomorrow. The bus leaves here at 4 o'clock.
Where have you been working the last year?
I've been cleaning houses, and then for about 2 months, I had got a job at Wesley Community Center. So you know how Tyson, they have their B shift, and so we would watch. They had a contract with the Tyson for us to watch the B shift children, but there wasn't enough employees, so they basically all of us, they were gonna just lay all of us off. So that's whenever I just put in my application and stuff at JBS. About the past year, I haven't been working. I was kind of had a little side, I don't know how you call it, I had a break of psychosis, but I did go to the pavilion and I got started on some medications, and I've
Where did
been
that come from?
balanced out now.
Okay, so Well, I'm gonna tell you this. I don't, well, it's, yeah, you should have contacted us. I'm gonna find that you're not indigent, but that you failed to make a good faith effort. And I have a hard time believing you're gonna start the job tomorrow. That's kind of what people say when they want to get out of jail, but
Yes!
I'm gonna remand you to custody of chief of police to sit out to, until such fine and court costs are paid. If the 762 is either paid or sat out, somebody can come pay it for you if you truly have a job starting. But you've had 2 years, 2 years.
Yeah, I understand.
Mhm.
How
So
many days would it be, if I do sit it
Oh.
sit it out?
760 divided by 150 is a 150 a day. So,
You should, Lucy.
Ooh, you're good at math. See, there you go. Yeah, it's fine. It's really, yeah, it's 5 or 6 days. Yeah, but somebody can come pay some of it down if you want to stay there less time.
How do I call? I know the phones are messed up here. How do I call and get a hold of somebody to do that?
I don't know. I didn't know the phones were messed up there. Is it, have they been messed up? You'll just have to ask your pod officer or I just don't know.
Okay.
So, y'all, the phones are just out. They'll allow you to call as soon as they can, I'm sure.
Okay.
Okay. Do you have any questions?
No, I don't.
Okay. All right. You may return to your pod. Thank you.
Thank you.
Thank you.
Fantastic.
We hope we convinced you to make that call to purchase this once-in-a-lifetime offer. And if we didn't, don't worry, because you will hear the same crap from someone else tomorrow. We are Time Records, and you have been served.
All right, let's go.
Good afternoon, Your Honor. William Amadeo, P76194 from Miss Brockbank. Both appear via Zoom. Waive a right to be present in person.
We are going to.
Ma'am, can you unmute
there.
yourself and state your name, please?
Yes.
Let's go.
Good morning, Your Honor.
Fresh
My name is
Hour.
Emily Brockbank.
Hold on 1 second, guys. Fresh Hour.
Good morning.
Oh,
Good
there
afternoon.
it is.
Defender Kellyanne campaign on behalf of Mr. Ing.
Okay, so we had a very good.
Good morning. Good afternoon, Your Honor. William Amadeo.
Fresh Hour had some wackadoodles today, and I got it. No one's been getting court clips of Fresh Hour, so I'm glad we get some Judge Barbie. I mean, she's beautiful, but Santos still my girl. But she does get aggressive here. I have to give it to her. She gets aggressive. Let's roll.
P76194 from Miss Brockbank. Both appear via Zoom. Waive a right to be present in person.
Ma'am, can you unmute yourself and state your name, please?
Yes. Good morning, Your Honor. My name is Emily Brockbank.
Mr. Amadeo.
Your Honor, at this time, I did receive a recommendation from probation. There was several documentations I did hand over, so there could have been a miscommunication there. I just found out about the new felony warrant in Oakland County, and she is in South Carolina in aftercare right now. So the issue we have, Judge, I don't know if we could solve it all today. If you give me an adjournment, there's a warrant in Oakland County. She's in aftercare in South Carolina, and there's a recommendation from probation. And I did supplement some of the things that probation put in the report. So I'd like some time to try to fix this mess if possible.
Can I see probation and counsel at the bench, please?
Correct, Carrie. Correct. Uh-oh. So Miss Brockbank and Judge Frashauer have had several confrontations, apparently. So they go into a breakout room, and I think I jump. Let me see. Yes, I do jump for you guys. So just give me a second. I don't want you to miss it. So hold on.
This is bad. This is really bad.
Oh, it's bad. Oh, it's bad. It's really bad. Okay, so here we go. I didn't have time to edit it, guys. Sorry. All right, here we go. So they're back from the breakout room.
You ready, Karen? Back on the record in State of Michigan versus Emily Brockbank.
William Amadeo, P76194 for Ms. Brockbank. Emily, please state your name for Judge Freshour.
Emily Brockbank, Your Honor.
We're here today for review.
We did have a breakout room, Judge, and I know you want to state some things on the record. I would ask for a 30-day adjournment to try to clean this up, and for what it's worth, Oakland County may allow me to Zoom if I take on her felony. I know your position, Agent Elder's position.
I did not grant her permission to leave and live in another state.
I know, Judge. You granted her permission to go to rehab.
Correct, and then return and contact probation upon completion, neither of which she's done.
And Your Honor, I did hand over the documentation I received. I will say, as I said in the breakout room, she does not have a home in Michigan now, which I know is not your problem. She has given up custody of her children. She is in aftercare. I think she should explain what aftercare means. And I understand you've given her a lot of breaks, but I do think this is a situation where she's basically indigent right now, living in another state. And I don't think she stayed in another state to disrespect your order, Judge. I think she was released from rehab. She has no money. She's being supported by her boyfriend, who she's living with. And there's a lot of moving parts there, Your Honor. But she has successfully completed rehab. And I think that's a positive for her. And as far as the new felony charge, that occurred, the allegation occurred prior to you sending her to jail.
I mean, she was sent to jail in part because she had a new charge out of Oakland County. So they're all related.
I understand. But the allegation, the time frame, I think it's important to note that she's done nothing wrong since you sent her to jail. I know it doesn't clean up where we're at, Your Honor, but I think it's important to note the time frame that there weren't new allegations that came out. This is from prior to you sending her to incarceration and rehab.
Why didn't you contact probation as soon as you got out? Why did probation have to hunt you down again?
Your Honor, I'm sorry. I was under the impression that it had been taken care of.
By who?
Well, before I was released, even from the rehabilitation.
How was you contacting probation handled?
I'm sorry. I had sent several emails to my attorney and I didn't realize that I needed.
Your attorney isn't you. Miss Elder doesn't want to hear from your attorney. Miss Elder wants to hear from you. It's not his responsibility to call probation. It's your responsibility. You're not new at this. You've been on probation for 2 years now.
Yes, Your Honor.
And I made myself very clear. You committed another, it's alleged that you committed another felony while you were on probation here. And I gave you an opportunity to go seek help, but I made it clear that you can go to this out-of-state program, but you must return. I did not say you could leave the state and go do whatever. We have no idea what you're doing now. Yes, you say you're an outpatient. I don't know what that means. We haven't received probation hasn't received any information about any outpatient treatment programming, what that entails, nothing. And Miss Elder is spending all her time contacting you. That's not her job.
Yes, Your Honor. I have all of that paperwork and all of the counselors and therapists and centers send her all that.
You need to return to Michigan, take care of the felony.
Yes, Your Honor.
Next.
I'll adjourn this to June 5th, 2023 at 2 p.m. You need to stay in contact with Miss Elder, not your attorney, not your boyfriend, not your mom, you. You call her and
Yes.
you talk to her. Do you understand that?
Yes, I do.
I'll adjourn the sentencing for that time.
Thank you, Judge.
Thank you, Your Honor.
Yeah. Looks you won't even look at her.
Case number 2.
All right. And then right after that, I stopped recording and then I hear her yelling again. So we had to go back. So here we go.
Defender Kellyanne campaign on behalf of Mr. Ng.
Zachary Ng.
Thank you.
Zachary Ng, probationary man of mystery, top left.
Have you gone over the recommendation with your client?
Yes, Your Honor, I have. So he actually sent me proof of the 45 hours of community service. I believe the place that he did the community service also sent it to Miss Elder, he informed me.
Ms. Elder, are you in receipt of that?
I did receive proof of 45 hours. I believe he is ordered to do 50.
Well, there were other hours before that. That was just 45 hours I did building those flower beds.
I don't have the proof of the other hours before that.
They have been sent to you before. I remember I gave that lady.
So
your
as of
email
November
and sent over to
21st, 2022, you still owed 50 hours of community
I
service.
have well over 50 hours of community
So,
service.
Mr. Ng, the problem is that we don't have that proof.
I have sent the proof. That's the thing.
So you'll need to resend it because Ms. Elder.
I
only
will.
did his last.
Hey, Mr. Ng.
Mr. Ng,
Yes, Your Honor.
I would watch it, sir.
Your Honor,
Yes.
may we ask for an adjournment for him to get those 5 hours to the court, please?
Yes.
Thank you.
We'll adjourn this. I'll extend your probation for 3 months to August 23rd, 2023 to complete the community service hours. I'll set a final review for August 7th, 2023 at 1 p.m.
Thank you, Your Honor.
Mr.
I'm sorry, I
Ng.
grabbed that. Case number 22.
We love okay. You see the title. Not gonna say it, but you have to listen to this case. This is out of Iowa. Whoa. It's pathetically funny. I'm gonna shut up. I'm gonna disappear, and I'm gonna let you nerds enjoy this one. And if you don't follow Jov Nafts, it's Nafts. Find them, subscribe. I gotta see if I have a link. I'll post a link. All right, ready?
Yes, sir. Can you hear me?
Yes. All right, we're going to take your case up.
Not to mention he has General Cornwallis, attorney at law over there. Look at that beard. He's got a badger on his neck.
Now, this is State of Idaho versus Hunter
Idaho.
Wooten.
Sorry, Idaho.
Case number is 0321-1745. Mr. Wooten is joining us through video conference. His attorney, Mr. Willis, is here in person. And we have Ms. Tognetti from the prosecuting attorney's office, along with probation and parole officer Scott Call. And this is the time and place set for further proceedings in this matter, where you had previously entered denials to your probation violations. Mr. Willis asked that the matter be set for further proceedings today. So Mr. Willis, I'll turn the time to you.
Thank you, Your Honor. And today we're prepared to admit with some edits and explanations. I'm prepared to admit the probation violations.
Thank you, Evelyn.
And if the court is ready, we were prepared to go to disposition also.
Okay. Are there any that he's not going to admit to or maintain his denial to?
Your Honor, we were going to admit to all of them. There were a couple that it was my understanding the state would correct the wording to reflect what Mr. Wooten's view of the facts were and what he could admit to.
Okay, so you'll stop me as we get there?
Yes.
All right. Mr. Wooten, is that what you want to do?
Yes, sir.
Okay. So looking at the probation violation of March of this year, the first term and condition was that you were to observe curfew restrictions. And it's alleged that on March 10th of this year, during a polygraph, you disclosed violating your curfew on multiple times. So, sir, do you admit or deny that you violated your probation by not, hold on, by violating your curfew?
I admit, Your Honor.
Okay. Next, you are not to leave the state of Idaho or your assigned district without permission from your probation officer. During that same polygraph, you admitted that on Saturday, February 25th, you went to Montana without permission. So, sir, do you admit or deny that you violated your probation by leaving the state without permission?
I admit, Your Honor.
Next, you are not to purchase, possess, or consume any alcohol or be in any business where the primary source of income is the sale of alcohol. And during that same polygraph, you admitted that you drank alcohol on weekends. So, sir, do you admit or deny that you violated your probation by not abstaining from the use of alcohol?
And Your Honor, that was one we had a disagreement with. The characterization that it was almost every weekend was not accurate. It was approximately twice a month. So
they did the polygraph because he was denying probation violations. So they said, put me under a polygraph. For those of you asking, it gets so much worse.
That's what Hunter would admit to.
So is that correct, Mr. Wooten?
Yes.
But you're admitting that you did not abstain from the use of alcohol?
Yes, Your Honor.
Is that satisfactory, Mr. Collins?
Idaho.
Yes, Your Honor.
All right, next, you are not to be in possession or consume controlled substances without a prescription. And it's alleged that you disclosed you had used illegal controlled substances, and you admitted to using marijuana and LSD. So, sir, do you admit or deny that you violated your probation by not abstaining from the use of controlled substances?
Your Honor, that was one other one we had an issue with. The LSD use he reported was prior to going on probation, but he admits to using marijuana and marijuana gummies on probation.
Correct, Mr. Wooten?
Yes, Your Honor.
So you admit or deny that you violated your probation by not abstaining from the use of marijuana?
Oh, I admit, Your Honor.
Is that satisfactory, Mr. Collins, Ms. Cognetti?
Yes, Your Honor.
All right, next, sir, you're not to be in possession of or purchase, produce, or view any material that portrays acts for sexual behavior, nor will you possess any materials containing male or female nudity. And sir, you admitted that you used a
sex toy.
Okay, that's what that is. So apparently you admitted that you used a sex toy in order to stimulate yourself. So, sir, do you admit or deny that you violated your probation by using material or an instrument that stimulated your sex organ?
I admit, Your Honor.
I'm sorry, what?
I admit, Your Honor.
All right, you're also not to subscribe to or use or have access to the internet without the permission of your probation officer and or treatment provider. And it's alleged that you have a smartphone and that you viewed pornography and access other platforms such as YouTube and TikTok and Facebook on your uncle's Wi-Fi.
So let's set the stage here. Charlie, Idaho is on probation, drinking a sixer, smoking a doob. Here we go. tripping balls on his uncle's Wi-Fi, sitting on a spinning it somewhere, watching That's a good night, my friend. And then he has to admit it and go under a lie detector test for it. Yikes.
You admit or deny?
I would hate for some of you, that's most of your weekends for some of you. If you're on probation, you may get lie detector tests for it.
That you violated your probation by having access to the internet without permission from your probation officer or treatment provider.
I admit, Your Honor.
Okay. You are also not to form or unite in a romantic interest or sexual relationship with any person without permission from your probation officer or treatment provider. And it's alleged that you admitted that you met with a woman in her 30s and she came to Pocatello in May of 2022, and that you had sexual intercourse with her without the permission from your probation officer or treatment provider. So, sir, do you admit or deny that you violated your probation by entering into an intimate relationship without permission from your PO or your treatment provider?
And then he got a cougar to come over and finish him off. That's nowhere on kitten court cases bingo cards. This is the adult bingo. Yikes.
I admit, Your Honor.
Boy. Did she use the toy?
You're also to obtain a sex offender evaluation and comply with all requirements of any treatment recommended and actively participate in that treatment.
He honestly, though, he must be a really bad sexual deviant to not even be able to have a partner without permission. I've never heard of that before. And the best part about it is, remember how we always talk about the grand scheme of things? It's a judge in a bow tie from Idaho reading the charges. It's one or two things. Either he's a freak himself or he doesn't even know what that sex toy was.
Till discharged successfully and not change treatment providers without permission. And it's alleged that when you were placed on probation back in March of last year, you were directed to engage in sex offender treatment at H&H, and it is alleged that you have not engaged in treatment. So, sir, do you admit or deny that you violated your probation by not engaging in and successfully completing sex offender treatment?
And Your Honor, that we would admit to with an explanation. So we have, when we do disposition.
All right, sir. I will accept your admissions as being knowingly and voluntarily given, and I'm fine with proceeding to disposition. Mr. Rutan, what we'll do is we'll hear from.
And he has no shot because not only is this Idaho and the judge has a bow tie, but his lawyer probably just rode to court in a horse and carriage.
Ms. Tognetti and Mr. Paul first, and then from Mr. Willis, and then anything you'd like to tell me. So,
Okay.
Ms. Tognetti, I'll turn the time to you.
Thank you, Your Honor. Your Honor, the underlying facts of this case, Mr. Wooten, when he was 20 years old, had sexual intercourse with a 15-year-old. Given his age and lack of criminal history, he was given the benefit of a reduced felony and probation. He is on sex offender probation. I think that given, I think that the underlying offense, I think it shows that it was opportunistic. I think it shows a lot of impulse control. And now seeing this, I find this very concerning. He's on probation for 10 years. He's not even allowed to apply for early termination for the first 6 because of the benefit he was given from this deal. I find that all of this occurring in the first year of his probation is very concerning. And it's not even just.
So he got the deal of a lifetime, and within the first 10 months of probation, he had a wild night. He had to get it out of his system. I would have been like, Judge, can probation start tomorrow? I just have a couple things I have to do, and then I'm good.
The alcohol use or curfew violations. It's having unapproved sexual contact. It's viewing pornography. It's using sex toys. It's things like that that got him into this position in the first place. And so I think that Mr. Call is absolutely correct. I think that it is time for a writer. I think that being given this opportunity just to go straight on to probation apparently wasn't the wake-up call that we hoped it would be. And I think that a writer at this point would be appropriate.
Thank you, Ms. Tugman. Mr. Paul, is there anything else you wanted to add?
My state.
Thank you, sir. Mr. Willis.
Thank you, Your Honor. I think in this case, it's important to look back to Dr. Hatzenbuehler's psychosexual evaluation. She had a lot of insight in that into Hunter's development and his character and ways that he could be successful on probation. The one thing that I do agree with Ms. Tugnetti on in her characterization of the offenses and recommendations is that we hoped that putting him on probation would be a wake-up call, and it clearly was not. I guess what I would highlight for the court today is that this is Mr. Wooten's first time actually serving time on this crime. The court may recall he was served a summons back at the beginning of this case some years ago. He voluntarily appeared at all of his court appearances, working with me, and we worked with the state to get the case resolved. And we do appreciate the offer that we were able to take advantage of with the state. But this is, Mr. Wooten didn't receive a wake-up call. He didn't ever go to jail prior to the probation violation of being picked up on the agent's warrant in March of this year. What I would like to highlight too is that there's no new criminal offenses. Mr. Wooten's conduct has been sad is the way I would characterize it, more than disturbing, that he just didn't take advantage of the services of probation or take advantage of even the clear direction that Mr. Call provided to him on several occasions. He kind of bumbled along and showed up once a month to check in with Mr. Call, was partially there, was mostly there, but he did, at the time of when they did the polygraph is when all of this came out, that he had been using alcohol, that he had been accessing the internet, and that he had traveled out of state and obtained drugs while he was in Montana. That was the most disturbing thing to me, is that clearly that's a boundary. He traveled out of state, he bought and used controlled substances, marijuana, while he was on probation. And those are, I guess, should be a clear boundary for any person. I think that's why it's important to look back at Dr. Hatzenbuehler's report, where she highlights that he had lots of behavioral problems as a youth. He had an ADHD diagnosis that should be reassessed by his treatment provider. He would benefit from additional assessment of his use substances and ongoing monitoring of his use of substances. His ability to manage his anger and manage himself. He would benefit from skills in assisting him to manage that and directing him to mindfulness. And what she highlighted was a lot of his cognitive deficits too, that he had an IEP in high school, which we provided to her when she did the evaluation. And she noted that he had limited intellectual abilities, adjustment disorder, mixed disturbance of emotions and conduct, and borderline intellectual functioning. What she related is that strict supervision would benefit Hunter, and I guess this case, he was given enough rope that he ended up hanging himself. I think none of this was Mr. Call's fault. Hunter clearly got the written instructions from the department at the beginning of probation, but I guess for a first-time sanction of being picked up and sent on a rider, to me seems like a very serious step. And I think him going to jail for, now he's been in jail 60 days, has been the wake-up call that Ms. Tognetti referenced, and certainly it's got his attention, and he had asked the court to be able to address you and apologize for his behavior and also tell you where he's at these days. Spending even just a month in jail when we were back before the court was a serious wake-up call to him. It's the longest he's ever been incarcerated, and he has vowed to make probation his top priority and do better if the court should see fit to put him on probation. I think that where the system kind of broke down is that even though he was checking in with Mr. Call every month, he may not have been being monitored as closely for the substance use and abuse, and for things like the curfew. There were no intermediate sanctions given. Where I would view his current jail time as the court could look at that as an intermediate sanction, that he now has served a significant period of time in jail. The court's got his attention, and he's been can be redirected to engage 100% with probation. The explanation we would offer for a couple of the probation violations, and again, the most significant thing I saw when I read the report is that he still had not engaged in sex offender treatment. Well, the court may recall, we hired Dr. Hatzenbuehler to do this as a private party case. So she conducted the psychosexual. We provided a copy to the court and the state, but Mr. Wooten was still working on paying that off when the court put him on probation. Normally that would be assessed as cost of probation or fees if the court paid for that. But Dr. Hatzenbuehler's office would not release the report to H&H, his new treatment provider, until he had paid for it in full. So he was working, and Mr. Call expressed some frustration that he was not working full-time or not working a well-paying job. So he was, again, bumbling along, paying $100 a month, trying to get Dr. Hatzenbuehler paid off in order to get the report to H&H so he could begin treatment. The other positive thing is he did finally obtain employment, making $18 an hour, working for a friend's family in the end of February. So he was on track to be much better off financially. He had paid off Dr. Hatzenbuehler, and he had actually met with the treatment provider and was scheduled to start treatment basically the 1st of March, approximately the same time he was picked up on the warrant. So it's not entirely accurate that he not engaged in sex offender treatment to the date of this report. He had actually taken the steps and had things lined up and finally had things in position to be able to take advantage of that service. The other explanation we had is that the romantic relationship he engaged in was with a 30-year-old woman. He had met that woman prior to going on probation. He did meet her online, and they had a plan that she would travel to Idaho to meet him in person before he was placed on probation. So what Hunter explained to me is he knew that this lady was coming to Idaho. He tried to get Mr. Call to meet her, to arrange for a meeting to get her approval. That didn't happen. She came to Idaho. I believe it was from Calgary, Canada, or she traveled some great distance. They did meet up, and they did proceed without Mr. Call being able to meet her or approve her. But again, this is not an underage person. It was a 30-year-old female with her own means and resources, and it was a prior relationship. Your Honor, the other significant thing is the accessing the internet. We did admit that Mr. Wooten used YouTube, TikTok, Facebook, and that he viewed pornography. There's no indication that he was ever seeking out underage people, or aside from the woman that he already knew, that he was seeking to form new romantic relationships. So even though he was violating, I think that is a smaller violation than it appears at first blush. What we'd ask the court to consider, Your Honor, is placing Mr. Wooten back on probation with this significant wake-up call. The other thing that I would suggest to the court is to consider either ordering him to do some period of work release or some period of checking into the jail every weekend for the next 60 or 90 days. I think that would continue to remind Mr. Wooten of his probation being his first priority. And the court could always send him on a rider if he continues to screw up, or if he screws up in a significant fashion and gets any new charges, or just continues to fail to work with Mr. Call. I think you've got his attention now. And with this interim sanction, or even an extension of that by having him check in every weekend to the jail, that he could be still a successful candidate on probation. now that we've got his attention. Thank you, Your Honor.
Thank you, Mr. Willis. Mr. Wooten, is there anything you want to tell me?
Yes, Your Honor.
Oh, here we go.
Both you and Scott for violating my probation. I've never served time before, and after serving time, it's been a rude awakening. I don't like it here at all. It's been hard.
No, it's been
I really miss my family and my uncle. My sister just had her baby too.
So
that's been hard.
Hard.
Sorry. I'd really like to see them. I'd really like to see them again.
So fake.
It's shown me the road that I'm going to be going down if I don't stop. Man, this is not the road that I want to go down.
Super's delight.
So this is the road not my stepdad, but my biological father went down, and it's not the one that I want to go down.
How fake is Hunter? Oh my God. Look at him. Oh, I didn't want the beads. The beads were calling me.
Pull myself together, I'm sorry. It's been hard.
You don't understand. They turned on the electric toothbrush and I just got flashbacks and I had to open my bottom drawer. And I was tripping balls.
So I'm sorry to both of you, and I'm going to make my probation a top priority. And that's something I've really come to conclusions with. It's not worth it. Nothing is worth coming here or to any place like this. And this is being here for this long has really shown me that.
What's up, my crazy?
So thank you, Your Honor.
All right. Well, thank you, Mr. Wooten. I appreciate your comments. Mr. Willis, is there any legal reason we should proceed to disposition?
No, Your Honor. Your Honor, Mr. Wooten reminded me of one other thing. He does have strong family support. His mother and stepfather are here, and they have been supportive of him along the whole process. His mother indicated to me through many conversations that she would also be taking a more active role in making sure he does what he needs to, even though he is an adult. He's still very childlike in a lot of ways. And so I guess that he has strong family support. And I think you heard that from him too. Thank you.
Thank you. So, Mr. Wooten, remember you have the opportunity to appeal any decision the court makes here. I've listened carefully to the comments from the state, from your attorney, and from you. I've also carefully reviewed the violations that you've admitted to. You've made admissions that you willfully violated your probation. And now I have to decide whether or not probation is achieving that goal of rehabilitation consistent with protection of society. And if not, whether I should revoke your probation and impose the suspended sentence. So this is what I'm going to do, sir. First of all, Mr. Willis, you know, I've talked to the Department of Corrections in the past about, we have treatment courts for all kinds of things, but we don't have one for sex offenders. And I've often wondered why not, but I think that there's issues with the Department of Corrections as far as whether or not they're willing to go that distance. But I've advocated in the past, maybe you can be an advocate for it.
Well, Mr. Call and I had a conversation that neither the GEO program nor the Crossroads would work with him while he is doing regular probation and also on a sex offender caseload. So that was
it's a no man's
we explored that avenue, and yes, it's a no man's land that was not an option for Mr. Wooten.
It really isn't, and that's unfortunate because we really have limited options. Mr. Wooten, you made some really poor choices, and they're your choices to do what you did. And I agree with Mr. Willis that you are still very immature, you're young, but I also agree with Ms. Tognetti in that your choices are very impulsive, and you don't think before you act like that. and how you have. And that concerns me greatly. And I think Ms. Cognetti is right. This is a case where you were given an opportunity to be placed on probation. I don't think you really understand how significant that was to give you an opportunity on probation because of the nature of the charges. But your risky behavior puts society at risk, and your choices have put society at risk. And so looking at that, I do find that probation is not achieving that goal of rehabilitation that's consistent with protection of society. And so, sir, what I'm going to do is I'm going to revoke your probation, and I am going to retain jurisdiction for up to 365 days. I do want you to work on your impulsivity and work on some maturity issues, work on achieving the goals that you need to be successful on probation, because you've got a long probation that you've got to be on. And if you can't be successful, then you'll have to go and do your time. And that's how serious I am about this. So I hope you reflect on that and take it very, very seriously. That's what the court's going to do here. Mr. Wilson, questions?
No, Your Honor.
And Ms. Tognetti and Mr. Paul, any questions?
No, Your Honor.
All right, sir. Good luck to you. I'm going to remand you back to the custody of sheriff to complete that program with the Department of Corrections. Good luck.
That was intense. Here we go. Judge Stevens lined them up and knocked them down. One after another. So I'm going to clip some of them for you, and we are going to go into Judge Stevens. He was dealing with the scourge of the world. Oh, we go from one chomo to another chomo.
This is. We have to pass that one. You just didn't hear it. Mr. Rodriguez.
Yeah, we need, actually,
We will
Bryant-
need it probably.
Bryant Rodriguez. Bryant Rodriguez. What are you gonna do on Mr. Moore?
I'm still working on one last thing before I make a final announcement.
All right. You gonna need some additional time?
I don't think so.
Oh, okay.
Just today. Just today, and plus whatever length of time it takes for the tablet to boot up.
We now call cause number 23-41485, the state of Texas versus Bryant Andrew Rodriguez. You are Mr. Rodriguez.
Yes, sir.
Present with Ms. Mantalini, your attorney, and the state's attorney. Earlier, you pleaded guilty in this cause number to the third-degree felony of online solicitation of a minor.
Yes, sir.
A pre-sentence report has been prepared and the parties had an opportunity to review it. And are there any objections or changes to it?
No, none from the defense.
None from the state. All right. Then it's made a part of the record for all purposes. Here in this agreement,
Make sure to hit that like.
the plea bargain agreement was whatever sentence shall not exceed a cap of 6 years in prison. So you're looking at no less than 2, no more than 6 years confinement in prison. Deferred or unadjudicated probation can be up to 10 years and length. Is regular probation?
Yes, sir.
It is also allowable. You could be sentenced up to 10 years in prison, probated for 10. Well, we can't do that either. We can't do on regular probation. It would be 6 years. No more than 6 years confinement, which would be on regular probation.
Yes, sir.
Suspended up to 10 years probation term.
Yes.
And a fine up to $10,000 is applicable on either one of those options. Okay, go ahead.
Your Honor, we are asking the court, of course, to grant him probation. I'm sure that if he were going to be granted probation and also had a chance to pick which one, we would be asking for deferred probation.
Thank you.
And I wanted to just go over a couple of things in his report. On page 2, the 4 entries that are dated 11/16/04 they were all out of the same event. I believe it was a bar fight or something, he tells me. And he didn't have any trouble with that probation. And then the theft, he had a probation on that one that he successfully completed. The next page on 3, the 6/2/14 wrongful use of cocaine, and it resulted in a reduction in grade. That was all the military. He was in the military at the time, and he explains later on that he had already re-upped, I think, his 3rd time, or he re-upped 3 times, right? And then on that 3rd time, he was technically wanting to change his mind, so to speak. So he knew he had to have a dirty urine. So he did drugs so that he would be able to be discharged. But and on page 4, you'll notice it says discharge type other than honorable. And so that allowed him to, in light of the fact that he did have a discharge due to the dirty urine sample, he still has all of his benefits available to him. He was not stripped of his benefits by that. He does tell me that he was diagnosed with post-traumatic disorder from the military in the medical division. And with the traumatic brain injuries, he had actually been shot at least once and been involved with 3 explosions while in the military. All of these are not excusing him. It's just giving you a little insight to who this person is. He has a relatively minimal criminal history, and this behavior is, even in light of anything that's listed in his criminal history, is totally out of the norm for what kinds of things he might have allowed himself to be involved with. I think it's interesting that he also is someone who says that they were physically, mentally, or emotionally abused, and that's on page 4. And he had made an outcry, he says, but nothing really happened from it. Again, that's not an excuse. It just kind of gives you a picture of who this person is that felt like it was the right thing to do to stay in the military as long as he did, even though it didn't end on the highest note. He did try to serve his country for quite a period of time. On page 5, the SATIC 99, the sex offender registration assessment tool shows that he is a low risk person for sex offender registration purposes only. And then in the evaluation for the Texas risk assessment, he also shows to be a low risk level. So at least there are 2 separate types of testing that show him as a low risk person to deal with while on probation. And the second paragraph of page 5 at the bottom under recommendations, where it states that he wrote that he was embarrassed, ashamed, and apologetic. It was terrible. He should have never put the young lady through that uncomfortable experience. She should have never had to experience the uncomfortness and feelings that she felt during the conversation. While the defendant expressed—
How old was this lady?
14.
While the
Yeah, let's
defendant—
get it straight. It's a child.
I didn't say anything.
You said young
different.
lady, but I mean, didn't make it
14,
sound like
I would consider a young lady, but I apologize if I misspoke.
there's a big difference. She's not even an adult. Right?
No, I guess
She's not an adult.
colloquially we say, "How you doing, young lady?" And it could be a young girl. Anyway, I stand corrected. While the defendant expressed remorse, it seemed he did not understand the severity of the offense. I'm not sure whether the probation officer gleaned that from the writing or if it was something in their conversation that made her feel that way. But every time I've spoken with him, I can tell that he does mean what he says. He does recognize how not only bad it was for him to even do what he did, but how bad it was for the girl to have to be a part of that. And I have never felt that he didn't understand the severity of this offense.
There were four girls involved in this, weren't there?
There was
Who
4
did that?
total girls present. The messages were sent to 1.
And finally, he is able to work. He has a lawn company that, and a, landscaping company that he could earn money. He's behind in his, probation. I'm sorry, behind in his child support. He knows that he's let his children down by getting himself involved, letting himself even do anything is unconscionable as this. But I don't think that he's beyond help. And we would ask the court to allow him to be released on deferred probation and let him work, pay his child support, make any reparations he could possibly. Understand as part of the probation rules, he would have to be participating in paying for any consultations that the child would have for psychological issues. And that's what we're asking, Your Honor, for him to be placed on probation. And I believe that if he was, even though the end of his service didn't turn out perfect, he apparently did well enough for them to accept him the extra times that he re-enlisted, and he's succeeded in other probations according to what he tells me. I don't have anything that indicate that anything different, and we would ask the judge to, the court, to allow him to have probation and to hopefully be successful in your court on that probation.
Judge, first thing I want to address is the static 99 risk assessment, and Ms. Mangiolini's, assertion, and it is in the PSI that he's a low risk among sex offenders. The static 99 is not an appropriate assessment tool for a non-contact offense like this is for online solicitation. It is designed for hands-on offenses. I want to point out the only reason we don't have an actual hands-on offense, while we don't have one or more cases of sexual assault of a child, is because of the victim and because of her friends, because of the kids who did the right thing. The defendant that night had his Facebook messages set in what's called disappear mode. So as soon as he sent the messages, they would disappear, which shows his intent. He knew what he was doing was wrong. That's why we don't have the whole conversations. The kids, the victim and her friends, one of which is the defendant's biological daughter, who was present for all of this and is friends with the victim, began taking screenshots, which he then instructed them to delete the screenshots because they could get him in trouble, and were actively hiding from the defendant in the same house. This is not a child he met on the internet that he didn't have immediate access to. This child was in the same home that he was that night, was hiding from him to get away from him, and he was making multiple attempts over these text messages. He talked to her in person that night, and this was a child who really he did not know very well. This was extremely high risk behavior, if you ask me. I don't think that he's low risk, but also that low risk label from these assessments is not low risk among the general population. It is low risk among other sex offenders. So he's still higher risk than the general population. He still has access to, if he were placed on probation, to children the same age. His biological daughter, who was present that night, was friends with the victim. His girlfriend, who he put in the PSI he intends to live with, her daughter was also present and there that night, and friends with the victim. And it's, but for these kids protecting themselves because the adults in the home were not protecting them, we'd have sexual assault of a child, we'd have delivery of a controlled substance to a child. The kids get credit for why we're not here for something more serious, not the defendant. And I would ask the court to sentence him to 6 years in TDC.
Would you like to say anything?
Yes, sir. And I would like to say that I'm sorry for my actions. Sorry to everybody that's here. I hope and I've prayed several times that Cameron and her family can get past the situation that's been caused by my actions. With the least amount of impact as possible. I just I'm not a monster, and I prayed every day not to be perceived as one, and it's I'm sorry from the bottom of my heart. I don't really know what to say, to be honest.
You know, why would you approach children in this way? I mean, this is disgusting. You want me to read this out loud? No, you don't, because it is gutter vulgar to have a child have to have that dropped in their lap. And it looks, what were you trying to do other than solicit a child for sex?
Well,
I mean, it's
there's
just forthright and crude, and a child, especially a 14-year-old, shouldn't have to have that thrown in their face. It's just terrible. It's disgusting. If you had a daughter and somebody did that to your daughter, what would you do to them? I know what you would do. Let's see. Here's what happened in Cameron Parish. I was at a bar. This guy grabbed my stuff, so I beat his ass. That's what you stated word for word.
Oh, look.
I'm sorry. Records were requested from the Cameron Parish Clerk of Court. When asked about the offense from Cameron Parish, the probation officer stated, "You said I was at a bar and this guy grabbed my stuff and I beat his ass." That's what you told the probation officer.
Whenever I was released from
There it is right here.
Yes.
You're not going to say the probation officer was lying to me, one of my officers, were you? I mean, they're pretty good at being verbatim. And it's Jody Roach, who's highly recognized as a proficient, more than proficient officer.
Yes.
And you're just dangerous guy. This is a third-degree felony. Yeah.
Cindy has executed the document admonishing him about registration. He understands it.
Whatever happens here in a minute is covered. Whatever option this court takes is covered under the sex offender registration admonishment. That you realize here that whatever option we take, you will have a reportable conviction or adjudication under law requiring you to comply with Chapter 62 of the Texas Code of Criminal Procedure, sex offender registration. Failing to do so is a criminal offense that may result in prosecution.
Yes, sir.
And if you move to another state that has similar reporting requirements, you must register in that state. Failing to do so would result with you being charged with a criminal offense. Do you understand?
Yes, sir.
I know. That's made a part of the record here. It's signed by the defendant and his attorney, and will be part of the record. Anything else?
No, Your Honor, but if you're not willing to allow him to at least show the court that he can be a successful probationer under your supervision, then we would ask that the court assess no more than 3 years in the penitentiary.
Anything else?
No, Your Honor.
All right, here's what I'm going to do. I'm going to find that there is sufficient evidence supporting this plea of guilty of this third-degree felony by the defendant's voluntary and knowing plea of guilty. to find the defendant guilty beyond a reasonable doubt based upon State's Exhibit 1 that's been admitted into evidence. I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. That will be suspended. You're going to be placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You also, as a condition of probation, shall serve 180 days in a county jail.
Yes, sir.
And that's day for day. You got 125 days. So you're going to serve 180 days, 6 months as a condition of probation. So you're not getting out anytime soon.
And the recommendations for the 2 ISF tracks, would the court be ordering those this time, or would that be something that once he's out, probation can determine whether
Yes.
they're necessary?
I'm going to defer to probation. They have substance abuse treatment and cognitive treatment track, which I think is the right thing.
Would the court consider those as if it were ultimately going to be facilities and classes that he would be going through, if the court would order those in lieu of the 180 days, because they would take at least 180 days to succeed?
Nope. You don't hurt a child like that. Yeah, I put one more.
You know, fill in the 180 days, Judge.
Okay, thanks. Shame of it all is that the shame of it all is that looking at your didn't see that. I'm sorry.
All right, guys. It cut on me. It was really nothing after that. Thank you for everything, people. Over 270 concurrent viewers. We are growing. We are rapidly approaching 10K. It's only been 4 months. This is a journey with all of you. I appreciate every one of you. Again, can't wait to see you guys nightly. I'm live every weekday and sometimes on the weekends. I have some clips, vault coming for members only this week. And Friday, we have a guest coming on Friday. Look out for it. You'll hear my big mouth yapping about it. Kitchen Court Cases is up live after me. Never go to bed angry. God bless. Give your family hugs and kisses. And just remember, I'm Phil. This is Time Served.